Hello students, how are you? Welcome to the channel and we are here again. फटाफट से बताओ, am I perfectly visible, perfectly audible for you? नहीं हूँ, फटाफट बताओ. और आज के सेशन में we are going to discuss constitutional law और उसके ऊपर we are going to have certain kind of questions today. फटाफट से give me a thumbs up whether I am perfectly visible and audible to you all. Good evening, Adrija. Okay. So constitutional law is one of my favorite subjects और हम उसको आज डील करने वाले हैं with respect to questions जितने भी होने वाले हैं, right? So the first question is principal fact based. हमारे क्लैट के पेपर में यूजुअली अब ऐसे क्वेश्चंस नहीं आते हैं, आजकल पैसेज बेस्ड ज्यादा क्वेश्चंस आते हैं, बट सपोज अगर ऐसा कोई क्वेश्चन आ जाता है तो यू शुड नो हाउ टू सॉल्व. दोनों ही टाइप के क्वेश्चंस आते हैं एक्चुअली, but passage based थोड़े ज़्यादा आते हैं. So the first question is on Article 19 itself. Every citizen has a freedom of conscience and and the right freely to profess, practice, and propagate religion. State may pass a law restrict. It's on Article 25. Law restrict any unreasonable religious practice. Okay. A particular religious section of the society perform the ritual of offering prayers 5 times a day, for which they made use of loudspeakers and loud musical instruments in the temples. This caused a lot of disturbance to the people living around these areas, especially in the in the hours of the day. Some residents filed a complaint with the requisite authority, which was justified by the religious sections by calling it their freedom of religious practice. A law was passed by the state which restricted the use of loudspeakers in any such religious ceremony. The section challenged the law is unconstitutional. Decide. So what is the question asking? The section challenged the law is unconstitutional. Now we have to decide whether the state has passed the law to restrict an unreasonable religious practice, hence it is valid. The state has not restricted the religious practice, but only restricted the method of such practice, hence the challenge won't sustain. They will succeed as by restricting the use of loudspeaker, the freedom to practice religion is violated. They will succeed, the right to practice religion is absolute and it cannot be restricted. What would be the answer? Give me the answer, students. Why B? The answer to the following question would be B, because the state has not restricted religious practice, that is for sure, जो हमारा principle कह रहा है, but only restricted the method of such practice. Hence, the challenge won't sustain. So there is another passage. Now we are covering the passage-based question. हमारे पास एक passage है, उसके बाद we are going to cover 5 questions for the same, right? This passage is on Article 21. So Article 21 of the Indian Constitution prohibits ex post facto laws. The expression ex post facto laws means a law which imposes penalties or convictions on the acts already done and increase the penalty for such acts. In other words, ex post facto law imposes penalties retrospectively. Right? For example, the Dowry Prohibition Act 1961 came into force from 25/1961. A person guilty of accepting dowry is punishable under the Act after 25/1961 and not before 25/1961. Ex post facto laws are of three kinds as follows. A law which declared some act or omission as an offense for the first time after the completion of that act or omission. A law which enhances the punishment or penalty for an offense subsequent to the commission of that offense. A law which prescribes a new and different procedure for the prosecution of an offense subsequent to the commission of that offense. So first is कि first law बोल रहा है कि अगर कुछ act or omission है for the first time हुआ है completion of that act and omission तभी भी वो law होगा. A law which enhances the punishment. अगर कोई ऐसा law है which enhances the punishment तो ऐसा भी काइंड ऑफ लॉ होगा, ठीक है, या पेनाल्टी एनहांस कर रहा है. एक लॉ व्हिच प्रिस्क्राइब्स अ न्यू और डिफरेंट प्रोसीजर फॉर द प्रोसिक्यूशन इज दैट वन ऑफ द लॉज. Clause 1, Article 20 provides protection only in respect to the above first two categories of ex post facto laws. Laws which declares acts as offences subsequent to the commission of those acts, and laws which enhances the penalty subsequently. Article 21 provides no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. The first part of Clause 1 provides that no person shall be convicted of any offence except for violation of law in force at the time of the commission of the act charged as an offence. The second part of the Clause 1 protects a person from penalty greater than that which he might have been subjected to at the time of the commission of the offence. The first question states, the Parliament of India legislated the sexual harassment at workplace in the year 2013, and simultaneously some new offences were also added to the Indian Penal Code 1860. Mr. A is an employee of an institution against whom departmental inquiry has been initiated for committing sexual harassment of a female colleague in the year 2012. Now choose the correct option. Such inquiry is valid as per Article 21 of the Constitution as the complaint was made after the Act came into force. Article 21 will not be applicable as the matter does not relate to an offence. As the Act was passed in the year 2013, any inquiry under such Act is invalid. Only inquiry may be conducted, but no penal actions can be taken against him after such inquiry. What would be the answer? Tell me the answer, students. So the answer would be only such inquiry is valid as per 21 of the one article of the Constitution, which is valid point. Article 21 will not be applicable as the matter does not relate to an offence. As the Act was passed in year 2013, third is also not valid. The answer would be only inquiry may be conducted, but no penal actions can be taken against him after such inquiry because the Act came into force later when he did the crime. It was already done and the Act came later, right? So the answer would be D. Article 21 would not affect which of the following acts of the legislature. Act of the legislature enhancing the term of imprisonment. Act of the legislature enhancing the amount of fine. Act of the legislature changing the punishment of death to life imprisonment. Act of legislature changing the nature of imprisonment from simple to rigorous. So the answer would be, we can do what all we can do. We can change the term of the imprisonment. We can even enhance the fine as well, but we cannot change the death to life imprisonment with any of the following acts, right? So yes, the third would not be that suitable option. So we are going to choose C. Other than that, all other is something very normal, or whether the simple to rigorous or enhancement of the imprisonment. हमारा जो पूरा पैसेज कहता है उसके अंदर जब भी हम तीनों पॉइंट्स पढ़ेंगे, expose factor of three kinds as follows. जब आप वो 3 points पढ़ोगे, then you'll realize what all are the initials that we have to take in. So only the C part is not going with what our passage is actually speaking about. Mr. A is a student of law, aged 19 years. He is socially active and expresses his opinion on every social and political event of the nation through social media platforms. In one of his blogs, he severely criticized the policy of the state government of changing names of cities and towns. He also stated that the government is biased towards a particular religion. The said blog was posted on 19th April 2020. Subsequently, an amendment was made to IPC whereby hate speech was made a distinct offence and punishment was prescribed. An action was brought against him under the said provision for the blog. Now choose the most appropriate option. Mr. A would be liable or Mr. A would not be liable? The answer would be Mr. A may be liable for the offense of hate speech as the blog was not removed even after the amendment. So what happened? The blog wasn't removed when even when the law was made, everything was done. So yes, he would be liable for the same. अगर वो blog हटा देता उस point पे तो वो liable नहीं होता, right? Considering the fact situation given in the above question, the Parliament passes a legislation in September 2020, whereby an amendment is made to the Juvenile Act, and now a person below the age of 20 would be a juvenile and special procedure would be followed for his trial. Choose the most appropriate option. Mr. A would not be considered as juvenile. It is prohibited under the scheme of Article 21. Mr. A would not be considered a juvenile because the amendment came after he committed the offence. Mr. A would be considered a juvenile and tried under the new procedure. None of the above. I believe, Adrija, the answer would be C. Mr. A would be considered a juvenile and tried under the new procedure. Right? Next and the last question for the passage. Considering the fact situation, the third question, the Parliament passes legislation for the probation of offenders, under which any offender below the age of 21 will not serve the sentence of imprisonment in a prison. Instead, he will serve the sentence in a probation house. Now choose the most appropriate option. Mr. A will get the benefit of Probation of Offenders Act. Mr. A will not get the benefit of Probation of Offenders Act as it is prohibited by Article 21 of the Constitution. It is discretion of Mr. A to decide whether he wants to such benefit or not. C is not at all option. None of the above is not the option. It can be A, either it can be B. So he will get benefit. For sure, he'll get a benefit. Mr. A will get the benefit of Provisions of Offenders Act. The next passage is on the doctrine of res judicata. The doctrine of res judicata requires that the party should not be allowed to file same matter repeatedly against the other party either in the same court or in other competent court, and that the decision given by one court should be accepted as final subject to any appeal, revision or review. The doctrine is founded on the principle that it is in interest of the public at large that a finality should be attached to the binding decision pronounced by courts of competent jurisdiction, and it is also in the public interest that individuals should not be waxed twice over the same kind of litigation. This apart, the object of the doctrine is to ensure that ultimately there should be an end to litigation. Doctrine of res judicata is embodied in Section 11 of the Code of Civil Procedure 1908, which governs the procedure to be followed in civil matters. Section 11 is inapplicable to writ jurisdiction. The Supreme Court has observed that though the rule is technical in nature, yet the general doctrine of res judicata is based on public policy and therefore it cannot be treated as irrelevant or inadmissible, even in dealing with fundamental rights in petition filed under Article 32 of the Constitution of India. The court observed that if a writ petition filed by party under Article 226 of the Constitution of India is considered on merits as a contested matter and is dismissed, the decision thus pronounced would continue to bind the parties unless otherwise modified or reversed in appeal or other appropriate proceeding permissible under the Constitution of India. It would not be open to a party to ignore the judgment of the High Court and move Supreme Court under Article 32 by an original petition made on the same facts for obtaining the same or similar orders of or writs. If the petition filed in the High Court under Article 226 is dismissed but not on the merits, then the dismissal of the writ petition would not constitute a bar to a subsequent petition under Article 32. However, if the petition is dismissed without passing a speaking order, then such dismissal cannot be treated as creating a bar of res judicata. The first question is, which of the following is res judicata applicable for? Is it for the civil suits, is it for the writ petitions, or is it for the both? It's a normal question, and it is already stated in the passage that I read above. So I think the answer would be both A and B. Civil suits के लिए भी applicable होता है res judicata और writ petitions के लिए भी applicable होता है res judicata. Doctrine of res judicata is applicable to writs if the decision is on merit or order is as a speaking order, both A and B, none of the above. The answer would be C. Again, doctrine of res judicata is applicable to writs if the decision is on merits and order is a speaking order as well. On which of the following is the doctrine of res judicata based? No one should be waxed twice for the same cause more than once. It is in the interest of public that finality should be attached to the decision of courts. There should be an end to litigation. All of these. I think all of these is the answer. All of these is the answer. Which of the following is correct? If a writ petition is filed under Article 226 of the Constitution of India and the same is rejected on merits by speaking order, another petition under Article 30 of the Constitution of India is not maintainable, being barred by res judicata. The doctrine of res judicata is founded on the principle that it is the interest of the public at large, then a finality should be attached to the binding decision pronounced by courts of competent jurisdiction. Technical rule of res judicata only prevents multiple filing of petition under Article 226 of the Constitution of India between same parties over the same matter is not applicable to petition under Article 32 of the Constitution of India. I think the C is not the correct option and answer D would be the correct option. Both A and B are the correct things. Mr. X was dismissed from service by his employer after a proper inquiry. Mr. X challenge is dismissible in High Court by a petition under Article 226 of the Constitution of India. However, the High Court dismissed the petition, citing that Mr. X has an alternative remedy available. Mr. X took recourse to the alternative remedy before the appropriate forum, but Mr. X's legal action is opposed by the employer on the basis of res judicata. Based on these facts, which of the following is the most appropriate? Res judicata is applicable, res judicata is not applicable. If the order is heard twice, then it would not be applicable as res judicata. So res judicata is not applicable as here in the same question. To maintain the secular character of the Indian polity, not only does the Constitution of India guarantee freedom of religion to individuals and groups, but it is also against the general policy of the Constitution of India that any money be paid out of the public funds for promoting or maintaining any particular religion. Accordingly, it is provided in the Constitution of India, no person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. This does not prohibit the state from enacting a law to incur expenses from the promotion or maintenance of any particular religion or religious denomination. But by such law, no person can be compelled to pay any tax, the proceeds of which are to be so utilized. This, however, does not invalidate levy or fee to provide same services. Thus, a fee can be levied on pilgrims to the religious fair to meet the expenses of measures taken to safeguard the health, safety, and welfare of the pilgrims. Such fee levied by the state will be valid because the object of such contribution is not to foster or preserve religion but to control secular administration of religious institution. Mr. A taxpayer of various taxes levied by the state government, filed a writ petition for issuance of a writ of mandamus directly the state to forbear from spending any amount from the public funds of the state for renovation of water tanks belonging to a Hindu temple in the state. These tanks were used by the general public, irrespective of their religious affiliation, for bathing and drinking purposes. Which of the following statement is correct? Here, the water tank that they are talking about is being used by each and every religion, right? So here, the state is promoting or maintaining Hindu religion? No, the state cannot be said to be promoting or maintaining the Hindu religion. Yes, they are not promoting. The state is compelling citizen to pay tax? No. The state is compelling pay to maintenance of Hindu religion? No. The answer would be P. Criminal rights between religion A and religion B result in the destruction of places of worship of both religions in the state. As a result, the state government utilized public funds for restoring the places of worship of both religions A and B. Which of the following statement is correct? The state government's act is violative of the constitution? No, the state government's act is not violative of the constitution as it is not promoting or maintaining any particular religion. That is correct. The state government's act is violative? No, the state government is not violative of the constitution as it is promoting or maintaining a particular religion. The option D is not correct, but option B is correct because they are not maintaining or promoting any kind of religion there. Communal rights between religion A and religion B resulted in the restriction of place worship. As a result, I think this question is being repeated. A state government passed a law making it mandatory for all residents of the state to pay up a hefty pilgrimage tax so as to aid the state in organizing a popular religious pilgrimage in that state. The such pilgrimage is undertaken only by followers of religion X and draws a large number of followers of religion X from all over the country to the state every year. Which of the following statement is correct? The state government's act is violative of the Constitution of India as it is not promoting or maintaining religion X. The state government's act is not violative. The state government's act is violative. There is one option which is violative with the one option which is not violative. Choose one. The answer would be C. The state government's act is violative of the Constitution of India as it is compelling citizens to pay tax for promoting or maintaining a religion X. The objective of state legislation is to provide for the better administration and governance of certain Hindu religious endowment, where religious endowment means the property belonging to or given or endowed for the support of temples. The state legislation vests the supervision of public temples in a statutory authority, that is, Commissioner of Hindu Religious Endowments. For the purpose of meeting the expenses of the commissioner and his staff, every Hindu temple in the state is required under provisions of the state legislation to pay an annual contribution at certain percentage of their annual income. Which of the following statement is correct regarding What would be the answer? It is not violated the Constitution of India because its object is the proper administration of religious trust and institutions. Right? Moving ahead with, we are coming up with All India Open Mock CLAT 2026 on 31st of August, this Sunday. And it would be a Sunday. It is going to be happening online and offline. If you really are interested in giving it offline, you can go and select your offline center and go and give it there. If you go for one AIM CLAT, it would be for 48 rupees. But if you're going for three, then it would be 99 rupees. And both other two All India Open Mocks will be conducted in next October and November, right? So make sure you are actually registering for the same and go and give it for sure. Last question. Writ is a public law remedy. It refers to a formal written order issued by a judicial. How many writs are there? कितने टाइप की writs होती हैं? जल्दी बताओ. Judicial authority directing an individual or authority to do or refrain from doing an act. The High Court, while exercising its power of judicial review, does not act as an appellate body. It is concerned with illegality, irrationality, and procedural impropriety of an order passed by the state or a statutory authority. High Court is empowered to issue directions, orders, or writs of the enforcement of fundamental rights and for any other purpose. The writ jurisdiction of High Court is discretionary and equitable. Writ of mandamus is issued by the court commanding a public authority to perform a public duty belonging to its office. It can be issued only when a legal duty is imposed on the authority and the petitioner has right to compel the performance of such duty. Writ of mandamus is requested to be issued inter alia to compel performance of public duties which may be administrative, ministerial, or statutory in nature. A writ of mandamus may be issued in favor of the person who establishes a legal right in himself. It may be issued against a person who has a mandatory legal duty to perform but has failed or has neglected to do so. Such a legal duty emanates by operation of law. The writ of mandamus is most extensive in regards to its remedial nature. The object of mandamus is to prevent disorder emanating from failure of justice and is required to be granted in all cases where law has established no specific remedy. The government of the state made a rule to make it discretionary to grant dearness allowance to its employees. One of its employees filed a writ petition seeking a mandamus to compel the government to grant dearness allowance. Which of the following statement is true? Give me the answer, Fatafat. The answer would be writ of mandamus cannot be granted as no legal duty was imposed on the government to grant dearness allowance. Right? A public-spirited citizen filed a writ petition seeking a mandamus to compel the government to make a law to curb the ill effects of climate change. Which of the following statement is true? The writ of mandamus cannot be granted. Can be granted? No. Writ of mandamus cannot be granted as no legal duty is imposed on the government to pass a law to curb the ill effects of the climate change. Mr. A and Mr. B are parties to a contract of sales of goods. Upon breach of contractual obligation by Mr. A, Mr. B filed a writ petition seeking an mandamus to compel Mr. A to perform his obligations under the contract. Which of the following statement is true? Writ of mandamus cannot be granted as there is violation of fundamental right. Writ of mandamus be granted as a discretionary remedy. Writ of mandamus cannot be granted as Mr. B's right under contract is a private right. Writ of mandamus can be granted as there is no statutory duty imposed on Mr. A to fulfill his contractual obligation. I believe the answer would be C. Writ of mandamus cannot be granted as Mr. B's right under the contract is a private right. A licensing officer is under a statutory duty to issue a license to an applicant who fulfills the condition prescribed for the issue of such license. Mr. X, an applicant, fulfilled all the conditions prescribed for the issue of such license, but his application for issuance of license was rejected by the licensing officer. Which of the following statement is correct? whether the writ of mandamus can be granted, whether the writ of mandamus cannot be granted, whether the writ of mandamus can be granted, whether the writ of mandamus cannot be granted. I believe the answer would be A, the writ of mandamus can be granted, but compelling the license officer to issue the license. Which of the following statement is incorrect? Writ of mandamus may be issued in favor of a person who establishes the existence of a legal right. Writ of mandamus may be issued against a person or authority who has a mandatory duty to perform but has failed or has neglected to do so. Writ of mandamus is purported to prevent disorder emanating from failure of justice. Writ of mandamus may be requested to be issued to compel performing of private duties which may be administrative, ministerial, or statutory in nature. The answer is going to be D. Writ of mandamus may be requested to be issued to compel performance of private duties which may be administrative, ministerial or statutory in nature. रिट के बारे में बहुत सारी अच्छी चीजें आई रियली बिलीव आप आर्टिकल 32, आर्टिकल 226 पढ़ रहे होंगे. आर्टिकल 32 में किसके पास पावर होती है, आर्टिकल 226 किसके पास पावर होती है, प्लीज कमेंट डाउन इन द कमेंट बॉक्स बिलो. And yes, that is it for the today's session. Thank you for joining in. I really hope you really like the session. Please like the button, subscribe the channel,